Any mention?
May it please your Lordship. Lordship, I crave Lordship indulgence in item number 5. Kindly have this matter next week, your Lordship. I have some personal difficulties today. Item 5, your Lordship, that is criminal appeal. After a week, your Lordship.
1 week.
How you like?
My lord, item number 6 and 7, I have been informed that there's a similar issue pending before court number 2 also. My lord, the issue here is we are challenging the clubbing of the merit list of the scheduled caste and the scheduled tribe, my lord, under that 5% reservations, my lord, without touching the entire reservation policy. So the similar issue I've been informed that has been pending before Justice. Thank you. So, my lord, this matter would be most appropriate, my lord, if these matters are clubbed together. The issues are clubbed together.
You see, there should not be any
Yes.
conflicting
Judgments, my lord.
if at all.
Yes, my lord. So, I was just, I will pass on to
It is for the parties to make a prayer that this matter be taken up by that court or
Lordship,
that
it
matter
cannot,
be taken up by this court.
that court cannot take up this to matter, your Lordship. This matter have been placed before your Lordship because it was recused by that court.
Oh.
But there's an issue, my lord, the issue, or my lord, we'll work out something, my lord, give us a week's time, my lord.
Or those matters can be taken up.
Yes.
It's up to you.
My lord.
Come after 3 weeks then.
2 weeks, my lord. 2 weeks.
2 weeks, sir.
Apply, your Lordship.
My lord, I also beg to mention item number 9. There's a criminal appeal, my lord. So, escape my notice, my lord. I could not prepare this case, my lord. 2 weeks, my lord.
2 weeks.
My lord. Obliged.
My lord, I beg to mention item number 11, Mr. S. Dev is there. It's a very new, I need some more time to prepare, my lord. Item number 11.
3 weeks. 3 weeks because we have many matters.
Obliged.
May it please, Lordship. Lordship, I beg to mention item number 10, Lordship. I didn't find the appellant counsel here.
Who's for the
S here.
We'll do one thing. Let the matter be called up. If the appellant appears, then you can make your submission.
It please, Lordship. Lordship, there are some matters which are listed under special drive, mediation drive, my lord.
That will take it up. The matters will be called out.
Very.
At that point of time, then you can make your submission.
May I please, Your Lordship? I beg to mention item number 8.
Yes, Mr. Jindal. This matter has been heard.
It was partly heard at one point last year. Then Lordship expressed Lordship's mind that maybe an attempt to mediate this matter can be attempted. However, my lord, there were 2 attempts. Both were not successful, my lord. Simply for the fact that claimant never turned up for this.
Are not willing or
They didn't turn up at all.
why? You are a claimant.
Yes, Lordship.
And the matter was because you see, I recall in this local that we have, particularly in MSC cases. Surprisingly, the last 2 or maybe 1 or twice, the insurance company will be there, claimant is not there.
Lordship, may this matter comes up after 2 weeks.
We'll refer it for mediation then. If there is, because you are to pay.
Here what has happened is, if Lordship recalls, it's a fairly old matter, but there was an age problem. In as much as there was no proofs submitted in terms of documents or ID cards, etc., to bring out the age. So what the learned MECT did was, the MECT took the age from the post-mortem report. Now that is not correct, ma'am. Post-mortem is not a...
Whatever the case is, those are technical...
technical. So if they can come up with some document, Lordship had instructed them also, please look for some.
We'll refer this matter for mediation. But you be sure to
As long as they turn up, my lord.
You be there. It's for your interest. If it's only an issue of of age, perhaps quantum may not be so much of an issue. Then it'll be to your advantage or benefit to get the matter resolved at the earliest.
That's why, Lordship, let's just need 1 more week to.
We'll refer the matter for mediation. You inform your parties, and then when the matter is taken up in mediation, then at that point of time you can resolve your issues or differences, whatever. To the 8 matters referred for mediation on being agreed to by the parties. Okay.
All right.
On supplementary list, item number 1.
That my lord had passed a judgment on 17th of this month. Less than 24 hours later, my lord, on 18th, respondents attempted to overturn that judgment, attempted to negate that judgment. And by doing so, my lord, they have committed contempt. I'll just take 2 minutes to explain how contempt has been committed. Firstly, my lord, if lordship is kind enough to look at the judgment that was passed, relevant para 48, my lord. That is at page 38.
Yes.
My lord, lordship will also recall the first appellate court, my lord, had held our lease deed of 1923 to be invalid. Now, at para 48, if lordship sees lordship's findings, in this respect, this court would agree with the contention of the learned counsel for the appellant herein that in view of the admission of the parties as to the existence or authenticity of the said lease deed dated so-and-so, the learned first appellate court could not have come to a finding that the said lease deed is not a valid deed. Such finding can be termed as a perverse finding not based on evidence, and this by itself can constitute a question of law to be decided by this court. It goes on, lordship has quoted a judgment of the Supreme Court. So the point from this para, my lord, is that lordship has found the lease deed to be a valid document, my lord. Number 1. Para 49, my lord. Even otherwise, on an overall analysis of the facts and circumstances of the case of the parties, including the evidence and the impugned judgments of the first appellate court, there is no finding or direction which has specifically bestowed the respondent clan with any relief. For example, that the respondent is allowed to take possession of the suit land. The suit land would remain intact as the possession of the appellant club over such land has not been disturbed. So again, my lord, I'll just pause. A finding from this honorable court on 17th that there is no disturbance to our suit land. Consequently, this being the case, the first question of law formulated has to be answered in the negative. The first question of law, my lord will recall, was whether in the absence of a counterclaim or a cross appeal, any relief can be granted to them. Lordship has clearly found no relief has ever been granted by any court, including first appellate court. No right of possession has been given. Our possession remains intact as on the date of this judgment. And this, I submit, my lord, this is the premise on which lordship had passed the entire subsequent part of the judgment. Para 51, my lord. The finding of the learned first appellate court on this count, as contended by the parties and so also favoured by this court, is indeed an erroneous finding and has no connection to the pleadings or evidence on record. Accordingly, this court finds that such findings cannot be the basis of any substantial question of law. No decision in this regard is required. However, since by reason of such finding, the finding, my lord, was that Transfer of Property Act does not apply to us. By reason of such finding, the right of the appellant club over the land covered by the said lease deed of 1923 has been affected. In this respect, this court hereby holds that the findings of the first appellate court cannot be sustained. 52. In view of this fact, this court finds that the judgment of the learned first appellate court, to the extent indicated above, is factually and legally flawed, and accordingly, the same is hereby set aside and quashed. So, lordship was pleased to interfere with the first appellate court's judgment. Para 53, my lord. Next para. The findings at paragraph 85 of the impugned judgment of the learned First Appellate Court would, however, be maintained. Para 85 of the impugned judgment, my lord, was the reflected the agreement of both parties that there is a valid lease deed of 1923, and lordship has reaffirmed that, my lord. Para 54, my lord. On the basis of the observations and findings as narrated herein above, this court hereby concludes that in any view of the matter, the right of the appellant club over the said land covered by the said lease deed of 1923 has not been disturbed. Again, my lord has reiterated the premise on which my lord is passing this judgment, that I am in possession and my possession is not being disturbed in any manner, my lord. Judgment goes on, second last para, my lord, para 56, page 43. In conclusion, this court, this is crucial, my lord. In conclusion, this court, except to the extent indicated herein above, so all the portions which I've read, my lord, except to that extent, finds no merits in the second appeal. The same is hereby dismissed. Now, this is where respondents, my lord, are trying to take advantage. Last line, my lord, appeal disposed of, no cause. So, lordship has interfered with the First Appellate Court's order. Lordship has held my lease deed to be a valid lease deed. In other words, I am a lawful lessee of that land. Lordship has noted that I am in possession and my possession is not being disturbed as on 17th February. On 18th February, they seek to overturn or negate or circumvent this judgment. Next page, my lord, page 44. They turn up at the land with barbed wires, bamboo poles, about 20-25 odd workers. Our members went to reason with them. These are the members. Lordship can see the barbed wire at their feet. If Lordship turns the pages, we took the liberty of attaching some photos of the site, showing clearly, my lord, the attempts at demarcating, marking out plots for sale, my lord. Having no other option, my lord, page 50. Page 50, we filed a complaint with the Superintendent of Police along with the local beat house. But, my lord, they were reluctant to interfere in this matter in any way. They have not interfered in any manner, my lord. And just to make, my lord, better understand the position on the ground, page 54, my lord. This, my lord, is a survey map prepared by the Meghalaya Survey Department, a government department, my lord. This was prepared on the orders of the trial court long back in 2014, my lord. The reason trial court ordered for this survey was to ascertain the area of the southern portion of the land, just to find out whether it comes to 6.72 that they are claiming was returned to them in 1923. Survey was conducted by the government department. Survey found, interestingly, if lordship looks at the map, right at the center is the clubhouse. There is a road kind of thing, my lord. And right in the center, there is a structure that is the clubhouse. Measurement was conducted from there till
about plot number 1, 2, or 3.
Yes, ma'am. So we are looking at plot number 1, madam. Plot number 1 is where they have entered,
Okay.
saying that this is the 6.73 acres. Government department, government survey has found plot number 1, if lordship looks at the table on the right hand side, plot number 1 amounts to 5.030 acres, not the 6.72 which they are claiming.
Okay.
Our contention is that our 10.19 starts from right at the bottom, goes up till where it goes up till 10.19 is achieved. So in other words, my lord, plot number 1 is also part of the suit land. It is part of the 10.19. They claim it is the 6.72. Government survey shows it is not 6.72. It is less than that. 1.72 acres less than that, my lord. So in any reading of the matter, that plot cannot be the plot that they are claiming. But my point is also that even assuming for a moment that there is some claim that they have some right over this portion, even assuming that, my lord, process has to be gone through, my lord. As lordship has observed, no court has ever given them any relief, right of possession, title, nothing. They have not filed anything. But through, I will have to say this, my lord, through brute force, they are trying to take possession of the land. And in doing so, my lord, anarchy is being committed, my lord. Anarchy is being committed. There is a process that has to be followed, my lord. Now, this is a contempt petition. The obvious question would be that What have they violated? Have they violated any direction of this honorable court? On the face of it, there is no direction against them, prohibition against them. But even in spite of the fact that there is no direction or prohibition, contempt has been committed. Supreme Court says so, my lord. What Supreme Court says in 2024, not too long back, Supreme Court says, my lord, that no direction or prohibition is required. If you are violating the spirit of an order, that is enough. That is contempt. Para 199, my lord. The contempt jurisdiction of this court cannot be construed by any formulaic or rigid approach. Merely because there is no prohibitory order or no specific direction issued, the same would not mean that the parties cannot be held guilty of contempt. The contempt jurisdiction of the court extends beyond the mere direct disobedience of explicit orders or prohibitory directions issued by the court. Even in the absence of such specific mandates, the deliberate conduct of parties aimed at frustrating court proceedings or circumventing its eventual decision may amount to contempt. This is because such actions strike at the heart of the judicial process, undermine its authority, and obstructing its ability to deliver justice effectively. The authority of courts must be respected not only in the letter of their orders, but also in the broader spirit of any proceedings between them. Next para is also important, my lord. Any contumacious conduct of the parties to bypass or nullify the decision of the court, or render it ineffective, or to frustrate the proceedings of the court, or to inure any undue advantage therefrom would amount to contempt. Attempts to sidestep the court's jurisdiction or manipulate the course of litigation through dishonest or obtrusive conduct or malign or distort the decisions of the court would inevitably tantamount to contempt, sans any prohibitory orders or directions to such effect. My lord, I will again go back to what Supreme Court has said. Any attempt, my lord, to frustrate the proceedings of the court or to inure any undue advantage therefrom would amount to contempt. Lordship has given fair relief to us by holding we are in possession, we are valid lessees, etc. However, at the end, Lordship was pleased to dismiss the appeal. Use the word dismiss. Advantage is being sought to be taken. We went to reason with them. We were told our appeal is dismissed. Please go away. But the dismissal, my lord, is a conditional dismissal. It is not a dismissal in totality. Lordship has said, except to the extent indicated above, there is no benefit. Indicated above is our possession, our rights as a valid lessee, my lord. So contempt has been committed. There is no prohibition on the face of the order. There is no direction or prohibition which they have violated, but they have sought to nullify my lord's order. They have sought to nullify my lord's order. That itself is contempt, my lord. And just one last point, my lord. This construction has gone on from 18th. It is still ongoing even as I am speaking, my lord. Contempt jurisdiction provides for restitution, my lord. Provides for undoing of a wrong. And this is again what the Supreme Court is clear about. If Lordship is kind enough to allow me to read one paragraph. Para 15, my lord. 1.5. However, in Mazdoor Sangha versus so-and-so, considering the aforesaid precedent, a two-judge bench of this court noted that the three-judge bench had clarified therein that directions which are explicit in the judgment or are plainly self-evident can be taken into account for the purpose of considering whether there is any disobedience or willful violation. The bench further held that the court has a duty to issue appropriate directions for remedying or rectifying the things done in violation of the court order, and in that regard, the court may even take restitutive measures at any stage of the proceedings. Even today, my lord has the power to order for restitution, to order for undoing of what has been done, my lord. Para 16, significantly, the two-judge bench has merely echoed the affirmation of the legal position by another two-judge bench of this court in DDA versus so-and-so. The principle that a contemnor ought not to be permitted to enjoy and or keep the fruits of his contempt was reiterated therein. Reference was made by the bench to Muhammad so-and-so, wherein it was held that undergoing punishment for contempt would not mean that the court is not entitled to give appropriate directions for remedying and rectifying the things done in violation of its orders. Para 17. Therefore, the principle that stands crystallized by these judgments is that in addition to punishing a contemner for disobeying its orders, the court can also ensure that such a contemner does not continue to enjoy the benefits of his disobedience by merely suffering the punishment meted out to him. So the principle of restitution, of restoring what has been done, my lord, that power is there even under contempt jurisdiction, my lord. And I would humbly submit, my lord, with all due respect, that this is a perfect case where lordship may kindly be pleased to exercise that power. Brute force has been used against us by sidestepping lordship's judgment. Contempt has been committed. They cannot be permitted to continue enjoying the fruits of the contempt by having those barbed wire fences on that property. As I said some time back also, they may have a right, but there is a due process that has to be followed, my lord. There is a due process that has to be followed. When lordship has held that we are in possession, no one is disturbing us, the very next day they seek to overturn that, my lord. Lordship, this is contempt, a fit case of contempt.
His Lordship, we are appearing for number 1. Number 2, my lord, has been passed away. My lord, please keep our attention at the other occasion. Number 2 has already passed away. 2 respondents are here, man. Number 2 has already passed away. That's 2014, man. 2024. We could have brought on the court earlier, man. We escaped, man. So we are appearing for number 1. Respond number 1. Oh, yes. Oh. May just submit the death certificate on number 2 on the court. We will supply to my esteemed colleagues. My lord, therefore, on behalf of number 1, may I submit, my lord, on behalf of respondent number 1.
What would be the, number 2 is part of the proceeding, yes. Was part of the proceeding. Yes. Eventually, you said he has expired in 2024. When the appeal was in progress.
Yes.
That should have been brought to the...
My lord, I could have brought on record or informed this honorable court.
At this point of time, what is required to be done?
My lord, therefore, my lord, leaving aside...
As far as your rights for and against the parties...
Yes. My lord. So leaving aside number 2, my lord, we are concerned with respondent number 1.
Anyway.
But my response to my esteemed colleague's submission is this, that the suit was filed. 2 leases were executed earlier, and first lease executed in favor of the Shillong Club, giving them 16 acres. Now subsequently, 10 acres, it was reduced again, this 1923, reduced to 10 acres to them, and we retained 6 acres, all throughout. And during the process, my lord, within that 6 acres, lordship is very aware, we lease out to 4 persons, including the village Tapa, where they have constructed their house and they stay there. They never dispute. They filed a suit 2013, suit was dismissed. We brought on record, they didn't file a suit. So trial court has dismissed that there is no case. They filed a first appeal also dismissed. Second appeal, my lord, has addressed the issue. Now the second appeal lordship addressed, the issue was whether, my lord, the relief was granted to me by the trial court or the first appellate court. That's the first issue. Second issue, whether the land transfer property, transfer property act is applicable in view of the application of the Assam Transfer Frontier Regulation 1880. That was the 2 issues only. Lordship has dealt with both the issues, and from the day 1 of trial court, we say that the suit, the land claimed by the plaintiff is absolutely beyond 10 acres. And we are not touching that 10 acres under the lease. They are occupying, they are using it. We are concerned with the 6 acres. And they did not describe that the 6 acres is within the suit land. Now, before this court also, we have considered that point, that we never claimed. What they are claiming is, my lord, in the name of that, using that lease deed, they are claiming extra 6 acres. Now, Lordship, the finding is very clear. Lordship, kindly come with me. Paragraph 41 of the page 35. But because here is the case, my lord, the contempt petitioner is trying to create a new situation. Paragraph 41, my lord.
Yes.
My lord, may I say, before deciding on the substantial question of law formulated by this court, it may not be out of place to refer to the evidence of the court. Particularly the fact that the appellant club plaintiff has asserted that the suit land comprises of an area of 10.19 acres covered by the said lease deed of 1923. It is also the evidence of the plaintiff PW1 that he has deposed that, in other words, no claim has raised by the club in respect of the 6.72 acres which were apparently relinquished in 1923. The respondent defendant client has also affirmed that the said lease deed is invalid deed, and therefore no claim has been made by the client as regards the 10.6 acres or even a portion of such land. Evidence also revealed that PW1 also aware that the local inspection on the suit property was directed and conducted on the conduct of the court, but the plaintiff club has objected to the said inspection. This, to the mind of this court, has cast a doubt as to the veracity of the claim of the plaintiff in the suit vis-a-vis the boundaries of the suit land. Lordship has seen. I would come to that map. They objected. Therefore, Lordship finding is this one. Now, another aspect of the matter. Now, these are the plot leased out to other parties. I mean, Lordship, may kindly come to page 37. 37. The last part of that para. This will have a bearing as far as the portion of 6.72 acres is concerned. So, Lordship came to know that yes, the area leased out to the other parties is part of these 6 acres. Now, under these circumstances, this court has find no reason to disturb the findings of the learned trial court. Now, paragraph 48, my friend has read out. I will not repeat it, my lord. That lease deed is with regard to 10.19 acres only. Now, Lordship, kindly see page 40, paragraph 49. The last part, this being the case, the first question of law formulated has to be answered in the negative. Because he has formulated. He came before this court, a relief has been granted to me. Lordship came with a negative finding. There is no relief given to me. Now the map, Lordship, can you see the map? Page 54.
But Mr. General, sorry to interrupt.
Yes.
When it comes to this map,
Yes, madam.
Yes, the map.
this is not, you see, nowhere was it brought in evidence.
My lord, I'll just explain why neither of the parties sought to bring it on evidence. Why they did not insist on exhibiting this was because their claim of 6.72 in that southern portion is negated by this map. Because plot number 1 is 5.
Whatever the case may be.
My lord.
See, whatever the case may be, this is a new fact. As far as the proceedings before this court is concerned,
My lord,
in the second appeal,
my lord.
even in the second appeal,
Yes,
you have not brought this by way of, additional evidence or whatever.
My lord, it's part of the records of the second appeal.
But you see, nothing specific has been mentioned.
My lord.
So, even otherwise, in second appeal, court cannot go into questions of facts.
My lord, true, my lord.
So, I know now at this stage,
My lord,
how will this help
my lord,
you?
this
Because this court
my
cannot
lord.
take
My lord.
even you see, even as a layman,
Yes, my lord.
if I look to this map,
Yes, my
there are clear demarcation.
Demarcation is
Plot number 1 is 5.03 030.
Oh, yes, my lord.
Plot number 2 is 10.19.
Yes, my lord.
So this is yours.
That is the list,
No,
1923.
So that is the reason why I did not insist on exhibiting this, because what the survey department did was they took the clubhouse as a center. The southern portion they measured, it came to 5.0. Northern portion till wherever it came to 10.19. our point was that the southern portion is also included within the 10.19.
That is why, you see, Mr. General,
Yes, ma'am.
at this stage,
No,
Exactly,
I don't think you can...
That was adjudicated by the trial
my
court,
lord,
first appellate
my lord,
court.
let me clarify, my lord. I am not looking for a finding from this honorable court that the southern portion is included within the 10.19. That will amount to modification of lordship's early judgment or adding something to lordship's early. I am not looking for that, my lord. The reason for placing this map for lordship's consideration is only to highlight the ground reality. The ground reality. So I am not placing this by way of evidence. I am not trying to add to the records of the second appeal, my lord. Nothing of that. No such intention. Just to show that the southern portion does not measure what they're claiming, 6.73. It does not come to that. So this is not by way of evidence. This is not by way of additional, some addition to the records of the second appeal. Nothing of that sort, my lord. Just to illustrate what is happening on the ground, what is the ground reality, my lord. That is all, my lord.
Compelling the court to take note of it.
Exactly.
My lord,
And may I just point out that
if it was
page
a,
54,
if it was a privately prepared document also prepared by us, for example, I would hesitate 10 times before placing it. It's a government document, my lord.
And at the relevant point of time, as has been observed from the records,
Yes, ma'am.
you have objected to this inspection.
We have objected only because they took the clubhouse as a center and
prevent
started measuring.
the authority to come
You
to
could
know
have
the
raised
exact.
that objection
So
at the relevant
my
point of time.
my objection against this map, the way the measurement has been done, in which direction it has been done, that objection still stands, my lord. That is the reason I didn't press on this during the hearing of the second appeal also, my lord. But just to illustrate what I am submitting today, that the southern portion, in any reading of the matter, either in any way that you look at it, including through this map, cannot be that 6.72. That is the only objective, my lord. That is the only objective, just to illustrate the ground reality, my lord. Just to illustrate the ground reality. So just to reiterate, my lord, no question, no intention of adding to the records, nothing of that sort, my lord. Just to illustrate that southern portion this is the portion that they are entering, my lord.
See, another aspect of the matter,
Yes, ma'am.
as has been observed by this
Yes,
court, from the records, and the proceedings before the trial court, first appellate court, there was no clear-cut demarcation of your boundary of the suit land.
My lord.
Now, subtly, you have approached the court, perhaps claiming, or rather, alleging encroachment.
Attempted encroachment. No.
Attempted encroachment. That has to be, backed by facts and evidence, which have not been done so.
Just to,
even on your own admission,
yes, madam.
as has been noted.
Yes, madam.
So, if you come to that, and the court, as you have pointed out, this court has what the court has done is upheld whatever has been held by the trial court.
Absolutely.
So, in effect,
yes, madam.
Again, I reiterate.
Yes, madam.
Your suit land remains intact. Now, if you say at this point of time,
yes, madam,
on 18th, maybe day before yesterday, whatever,
yes, madam,
attempt has been made to again enter into your suit land,
yes, madam,
that would be a different course of action altogether. Not a violation of this court order.
My lord,
because you have, contempt jurisdiction. If there's a alternative remedy available to you, that should be a first recourse.
My lord,
that has not been done.
My lord, if lordship allows me quick two responses, my lord. First, my lord, the attempt of every court would be to avoid multiplicity of proceedings. Number one. Number two, my lord, the contempt stares us in the face, my lord. The contempt committed by the respondents. So even without reference to this map, if lordship considers this map is not part of my petition also, the other materials clearly establish contempt. Contempt as defined by Supreme Court in this 2024 judgment, that even though there is no prohibition against you, you have done something to negate a judgment, to circumvent a judgment. Lordship's judgment has clearly held that as on 17th, I am in possession.
Exactly.
Now, there may be a controversy between us as to whether that southern portion of 5.03 is part of 10.19 or not, etc. They are welcome to raise that claim. But there is a way to raise that claim. The way is not by bringing workers and putting up barbed wire fences, my lord. So that act, my lord, if it amounts to contempt, and it clearly does as per Supreme Court, lordship has the power to intervene, my lord.
You're right. If you have been, if you have been able to make out,
yes,
that they have invaded,
yes,
your portion of land,
10 acres,
then
yes, my lord.
But their assertion, if I understand correctly, is that it is, outside the
Exactly.
purview or boundaries of your land.
Yes, my lord.
So now, who is right, who is wrong? It's not for this court to decide.
Exactly.
No, I agree with my lord, but our assertions from day one, from the time of filing of the suit, my lord, is that the southern portion also is part of the 10.19 acres. That is the premise on which we had filed the suit. Suit was dismissed. That is the premise on which we had filed the first appeal. First appeal also dismissed. That is the premise on which we had come before this honorable court. And honorable court has agreed that yes, you are in possession of the 10.19 acres. In other words, the southern portion also, because that is our assertion. Their assertion may be different. They can raise that assertion, they can raise that claim, my lord. But this, but by violating lordship's finding or by circumventing lordship's finding of possession, they are committing contempt, my lord. So my right to file a suit, etc., may or may not exist, my lord. I'm not on that at the moment. But lordship's order is being circumvented, and the circumvention is so clear, my lord. So if lordship does not intervene.
Where is I don't understand. Where's the
I'll place my lord.
prima facie
Exactly.
evidence in this regard?
But I'll place the three Supreme Court decisions. My lordship may take the pain to see page number 54 again. I'll just point out what my friend, though it is not a part of the record, the map. Lordship, plot number 1. But therefore, I'll just point out, my lord, what even the 4 suits are still pending. Lordship, kindly take the pain to see page 54. Now, between plot number 1 and 2, my lord, the maps are there, the roads are there. These are the area which we lease out to the village authority for privates, people. And they constructed the house and they're staying there. In between plot number 1 and 2.
Those cross.
The cross one. My lord, regarding this, my lord, 4 suits are still pending, filed by the Shillong law. Now, what they are unable to succeed through the suit, they want to succeed through the contempt petition. Now, if we enter in their 10 acres, my lord, my friend may be right. But we are entering our own land that within 6 acres. Within 6 acres. My lord.
But where is
so
the 6
how
acres?
the contempt court would
There is no
determine
6
this?
acres here, man.
I place the 3 judgments.
Yes. I got your point.
Yes, madam.
But that is exactly your stand.
Yes, madam.
Throughout.
Yes, madam.
That is your stand.
Yes,
that this portion of this plot A,
Yes,
plot one, for example, is within, is contained within that 10.19.
Yes, madam. That is true.
And what about this plot 3? We don't know.
Plot 3 is something else.
Plot 3 belong to the other clan.
Okay.
Other clan.
So between the extreme part of plot 1 and plot 2.
Yes, madam. Yes, madam.
Then at some point, at some place when you divide the land, or rather if you take it cumulatively, then it would be 10.19 plus 6.72. Should be.
If I can,
where do you get that 6.72 then?
If I can differ with my lord, plot 1 is 5.003. So till the road,
till that road, partly we have given to the village authority and the 4 persons.
So till that road is 5.03. Measuring further on till we reach 10.19 is our 1923 land, 1923 lease land. So our point is that plot 1 is also part of the 10.19, which lordship has also observed. Now again, my lord, I will request that if this map is the reason of causing some sort of confusion, the map may be ignored. Contempt has been committed, my lord. Contempt has been committed. Lordship has observed on 17 that I am in possession, I am not, and there is no disturbance. And on that foundation, on that premise, Lordship has passed the judgment which Lordship has passed. The very next day, the premise, the foundation of Lordship's judgment is being sought to be destroyed. That is contempt as per Supreme Court, my lord. So if contempt is being committed, my lord, with all respect at my disposal, I have to point out that this court cannot wash its hands of the matter, my lord. Because contempt.
The point is this, Mr. Again, like I said,
yes,
you have to convince this court,
yes,
that contempt has indeed been committed.
Yes, lord.
In as much as evidence will show that the order passed has been violated, in what manner it has been done so.
My lord.
Perhaps you're saying that they are trying to, by brute force, enter into the sued land.
Yes, madam.
Which this court has decided otherwise. But that, you see, there is no evidence on record for that.
No privacy. It's the abuse of process.
My lord, the evidence from my side At the
You
moment,
show some photographs.
my lord,
What does it?
what photograph plus police complaint. Now it is up to the respondents to submit before this honorable court whether they have entered the land on 18th or they have not entered. If the answer is no, that would be a lie, but lordship can record that and on the basis pass necessary orders. But the reality is that they have entered the land. I will eagerly wait for my senior friend to say that they have not entered the land. He cannot say that.
We are entering our own land within 6 acres. We never enter from the beginning.
That is the contempt.
Lordship no, not at all. Lordship never give them beyond 10 acres. Trial court, first appellate court never give them beyond 10 acres. And 10 acres they are occupying. What they fail to achieve in true suits, they are trying to achieve through the contempt. Lordship kindly, I'll place the 3 judgments. No contempt is made out, no primacy is made out, my lord. If they have grievance with the lordship judgment, there's an appellate forum. They can file a civil appeal for Supreme
We have
Court.
no grievance.
My lord,
we have no grievance.
2004 volume, 2003 2 volume 4, my lord. I'll just place 3 judgment and urge, my lord, that this case should be dismissed, my lord. No observation is required. If lordship made some observation, then they will take advantage again. My lord, may I just place 2002 volume 4 is a C, page 21. Relevant para would be 15. My lord, the way they interpret the lordship judgment as if they got the relief. So there are 2 interpretations available, my lord. The
Just a moment.
contempt court, my lord.
Just a moment.
My lord.
2002 4.
2002 volume 4 ECC page 21, relevant paragraph 15.
Yes.
The way my esteemed colleague interprets your lordship order as if they got the relief and were violating lordship order. That is a wrong interpretation. I have my own, my lord. In such circumstances, my lord, the jurisdiction of the contempt court. Para 15, my lord.
Yes.
It may be also noticed at this juncture that mere disobedience of an order may not be sufficient to amount to a civil contempt within the meaning of Section 2B of the Act of 1971. The element of willingness is an indispensable requirement to bring home the charge within the meaning of the Act. And lastly, it is important, in the event 2 interpretations are possible and the action of the alleged contemptor pertains to one such interpretation, the act or acts cannot be ascribed to be otherwise contumacious in nature. A doubt in the matter as regards the willful nature of the conduct, if raised, question of success in the contempt petition would not arise. It's very clear. Law is very clear. If there is 2 interpretations, one interpreted by me, one another, lordship jurisdiction is, contempt jurisdiction is not there. Number 2, my lord. 2004, volume 13. ACC, my lord. Page number 6, 261. 610. 610. But relevant paragraph would be 7.
Yes.
My lord, para 7, with lordship permission. On the basis of what has been indicated above, the first submission is that there is no violation of the order passed by the learned single judge directing regularization of the employees, since the said order has not been violated in any manner. The matter was considered in the light of the scheme for regularization that is and such. Secondly, it is submitted that the contempt court had no jurisdiction to issue any direction providing any substantive relief to the petitioners moving the contempt petition. In support of this contention, reliance has been placed upon decision of this court in such and such. There is no doubt about the position under the law that in the contempt proceedings, no further directions could be issued by the court. In case it is found that there is a violation of the order passed by the court may punish the condemner, otherwise notice of contempt is to be discharged. An order passed in the contempt petition could not be a supplementary order to the main order granting relief. My humble submission, my lord, which they fail to obtain the relief from any courts. They are trying to obtain some direction, my lord, observation from this honorable court through contempt. Is absolutely impermissible. The last decision, my lord, 2004 volume 7, volume 7, page number 261, relevant paragraph 5, my lord. Para 5. With lordship permission, madam. While dealing with an application for contempt, the court is really concerned with the question whether the earlier decision which has received its finality had been complied with or not. It would not be permissible for a court to examine the correctness of the earlier decision which has not been assailed, or to take a view different than what was taken in the earlier decision. A similar view was taken in such and such case. The court exercising contempt jurisdiction is primarily concerned with the question of contumacious conduct of the party who is alleged to have been committed default in complying with the direction in the judgment order. If there was no ambiguity or indefiniteness in the order, it is for the party concerned to approach the higher court, if according to him the same is not legally tenable. Such a question has necessary to be agitated before the higher court. The court exercising contempt jurisdiction cannot take upon itself power to decide the original proceedings in a manner not dealt with by the court passing the judgment order. It's very, very clear, my lord. The way my friend projects, my lord, inviting lordship to enter into the original disputes. That such an invitation, lordship should decline it, my lord. Because once lordship enter exercising contempt jurisdiction, my lord, there would be a revisiting of the entire issues which were already addressed by the trial court in full dress trial, first appellate court, and my lord as a second appellate authority, my lord. So this contempt petition, my lord, there is no merits at all, there is no primacy. Admittedly, my friend fair enough to consider that there was no positive direction against me. So if there is no positive direction against me, when is the violation, my lord? There is no violation, my lord. So lordship may kindly dismiss. No observation whatsoever may be made, otherwise they may take advantage. Otherwise, on the merits of the lordship order, there is a forum for them. So lordship may dismiss the contempt petition.
I'll just quickly respond to these judgments, my lord. These three judgments cited by my friend. 2002 4 SCC, my lord. The first judgment cited. The crux of this judgment, according to the respondents, is when there are two interpretations possible, then contempt jurisdiction is ousted, my lord. What I'm banking on, my lord, is paras 48 and 49 of lordship's 17th February judgment, where lordship has unequivocally held I am in possession and my lease deed is valid. There are no two interpretations possible, and I don't think respondents are attempting a second interpretation to paras 48 and 49. That is the foundation on which I am resting today, my lord. So this judgment has its place, but it has no application in our case, because what I am banking on is not susceptible to two interpretations. There is only one obvious interpretation. The next two judgments are more or less similar. 2004 13 SCC, 2004 7 SCC, both say more or less the same thing, that under contempt jurisdiction, no further directions can be issued. If there is a judgment directing a certain thing and there is violation of that direction, then you decide the contempt issue. You punish the contemnor if required, but no further directions can be issued. Lordship, with respect, 2004 13 SCC, 2004 7 SCC, the law has progressed after that. In the 20 years after that, 2024 Supreme Court was pleased to clarify that in contempt jurisdiction, you can not merely punish, you can restitute. You can order for something to be done, to be undone, which was done after the judgment was passed, my lord. So these judgments, had they had their time 20 years back, law has moved on, my lord. 2024 is very clear that contempt jurisdiction is not restricted only to punishment. It can go, when circumstances require, it can go beyond. And in this case, my lord, circumstances do require, I keep using that word brute force, it's a very ugly word, my lord, but that is exactly what has happened. So there is a forum for everyone, my lord. There is a forum for everyone. Till today, they have not gone to any single forum to raise any claim. After lordship's judgment, they come with brute force, my lord. That cannot be allowed. This anarchy, my lord, cannot be condoned.
2024 judgment, that proposition of law, I have no disputes. But here is the case, my lord, there is no contempt. If contempt is made out, lordship may exercise the power for restitution. But here, my lord, there is no contempt in the present petition. The judgment cited by my colleague is not applicable.
Yeah, for the parties.
Well, published. Deeply.
Let me go through these judgment and I'll pass and see orders.
Obliged.
Item number 2.
Mediation. Standard Ganita.
May I please, Your Lordship? My Lord, this is the second bail I have filed before this honorable court. In this case, my lord, a small quantity of contraband. Yes.
What is the fresh circumstances?
Fresh circumstances is that, your lordship, that witnesses upon which they relied, they have already been examined, 7 witnesses. A small quantity was recovered from the possession. She has been in custody for 1 year and 5 months. The punishment prescribed for the small quantity is, it can go to the extent of 1 year and fine of rupees 10,000. So, my lord, in this case, what happened? A small quantity of contraband was recovered, for which the maximum punishment is 1 year. She was arrested on 25/9/2024, and GO, gazetted officer, was called upon the spot in her residence, and she was searched in presence of the gazetted officer. Nothing was recovered from her possession. They said that it was recovered small quantity from her house, but for body search nothing was recovered. Now it was alleged that during the search of the petitioner accused by the gazetted officer, it was alleged that somebody, a lady called Noor Jahan, walked up to the police and told them that this accused person has kept another contraband in her shop. She led the police. It is alleged that some contraband, 6 point something gram, was recovered. Now this 6.5 gram, the police considered as recovered from my possession. Now, my lord, this Noor Jahan witnesses, thereafter I filed the bail application. This Honorable Court was pleased to reject. I approached the Honorable Supreme Court. Honorable Supreme Court upheld this order of this Honorable Court, and your lordship directed to expedite the trial. As of now, 7 witnesses out of 13 witnesses has been examined. 8 witnesses still remain, and it appears that FSL was not cited. They may summon, that means 8 or 9 witnesses will be there. It will take another at least 5-6 months. So even if your lordship will take into consideration that 3 points something and 6, it will be 9 gram. So applying the proportionality of the punishment, even I have already suffered. Now, my lord, I am not on that. Even if we will consider all the entire, then also, your lordship, I have already suffered substantial portion of the punishment. Now, my lord, I am not on that. The prosecution alleged that Noor Jahan came, she led the police, and on her leading, something was recovered from her shop. Now, this is the rare case, your lordship, that police convincingly believed this Noor Jahan, and at the very threshold, they overturned the presumption under section 54, and they did not arrest her. They cited her as a witness. Now, my lord, after this bail was rejected, then trial proceeded. Then during the course of the trial, PW4, Noor Jahan was called as a witness as a PW4. Now when she come, your lordship, she was found to be suffering from fractured backbone. It is reflected in the order sheet also. She was allowed to depose by sitting in the chair. Now she turned hostile. She said that, your lordship, that I have enclosed, she said that she has never led the police, she has never told the police that some contraband has been kept inside her shop, and she also said that, your lordship, that nothing was given by the accused person for safekeeping in her shop. The second allegation was that it was in presence of gazetted officer. Now gazetted officer has also been summoned, my lord, where it was alleged that in her presence only when the body search was going on, then Noor Jahan came. This gazetted officer is Deputy Superintendent of Police. She has not whispered and she has not said, your lordship, that any Noor Jahan came and revealed such thing. Now, my lord, she has said that only body search was there, and already some contraband was recovered, which was there in the residence of the accused person, and she said that thereafter she left. So, my lord, the allegation that during the search of the body search, Noor Jahan came, it is belied. Now, 2 independent witnesses also came and has been examined. They also did not whisper, your lordship, that any such lady came and say something. 2 police officers also, one is the witness, one police officer who searched the body of the accused in presence of she also not whispered. Now, my lord, in these circumstances, there is nothing, your lordship, there is no more witness who will say and who will prove, except Nur Jahan, that they have witnessed that accused kept the contraband inside her shop. Presuming also that contraband was recovered from the shop of Nur Jahan, that witness. I am not accountable for that because there is no more witness. So what I am liable, your lordship, is that for a small quantity, which I have already served the punishment, maximum punishment, more than maximum punishment. So on this fresh ground, my lord, I am praying for bail, my lord.
You have enclosed this deposition?
Yes, my lord. I will just take your, my lord, to this Nur Jahan. It is in page number, my lord. It's 68. My lord, page number 68.
Yes.
What's this? My lord, page number 68. I'll just read the evidence of this Nur Jahan. It's a very small paragraph, my lord. She has said, your lordship, that I am born and brought up at Lower Paltan Bazaar. I do not remember from which year that I have been set up a shop. It has been 8 years since my husband passed away. I know the accused person is, as the house of her sister is adjacent to mine. The accused person stayed in the house of her sister and she asked of my well-being, and I informed that I am okay, and accused told me that she has to appear before the court when they will stay for 3 days and return back to her village. Her sister, who has taken a rent of the house which was adjacent to my house, has left to her village, and the accused stay in the house of her sister and used to return in the evening to sleep. I do not remember the date that the police came along with the accused in which they have done the search, and I was informed the search to be conducted, and from and under my bed they recovered some contraband, but I do not know who has kept the contraband container under my bed, as I was fast asleep. So, my lord, thereafter the prosecution prayed for turning the witness hostile. After she was turned hostile, the prosecution cross-examined, my lord, the cross-examination of the prosecution. I cannot say for how many years I have been known the accused person, but I used to see her passing by my shop. The accused person never visited my house. I did not state to the police under section 161 CRPC that the accused has kept some container inside my shop. The accused person has not given anything to me for safekeeping. I can identify the accused person. Now, because just I have asked your lordship that since how long she has been suffering, she has said I have been suffering from ailments since last 8 years. So, my lord, she has totally negated the allegation of the prosecution. Now, my lord, the other witnesses also, my lord, they have not whispered that Nur Jahan came. She is not the only one. The other witnesses also they have not said. On the vital witness is that your lordship, this GO, I will take your lordship to the statement of the GO because she will be more reliable person. It is in page number 84, my lord. She has said that, my lord, I joined Meghalaya Police in the year 2012 and currently I am posted as SP in Anti-Terror Scout. In the year 2024, I was posted at CID as DY SP ASB Anti-Corruption Branch. On 29th September 2024, between 2:30 to 4:30 p.m., I received a call from SI Edward Khatpran informing that there was one female accused which was being apprehended and detained at Jhalupara, where a few narcotic substances were seized. When I received a call from SI Edward Khatpran, I was at the office at CID headquarters. I was informed by SI Edward Khatpran to be present at the PO as the accused is a female and my presence is required for authorization of body search of the accused person or searching the PO at 5 p.m. There was one WPSI and one WPSI wherein I authorized both women police sub-inspector and women police for conducting body search of the female accused person. The body search was conducted in my presence and in presence of 2 witnesses, and the accused person was carrying a black sling bag, and inside her bag cash amount of rupees 27,000 was recovered, ID of the accused person such and such, and one Realme mobile phone. My role in the connection in this case is to give authorization for body search of the accused person, but I also witnessed some narcotic substance was there inside the room on the desk of her residence. Exhibit 2 is the authorization for the body search, PCH Momin, and Exhibit 2 is my signature. On being shown to me my identity, I identify material exhibit, which is the epic card belonging to the accused, and material exhibit is the one
Go
mobile.
into the relevant portion.
Relevant portion, she has not said, Your Honor, that Noor Jahan came. That's why I am reading, my lord. Nothing has been said. She said that body search was there, and she has not whispered that, which is reflected in the FIR, on the basis of which they considered that 6 gram was also on the reading of Noor Jahan. She has also not said that during the search any Noor Jahan came. That is the only thing. So even presuming, my lord, that something was recovered, that small quantity was recovered, which I have been already undergone. Now, my lord, 6 gram also, at worst, let us presume, my lord, that one also they will consider to be my. Then also 9 gram, I have gone already 1 year, 5 months, my lord. So the second recovery, my lord,
9
there
grams,
is no.
9 grams is a commercial.
No, my lord, it is a small one.
Intermediate,
250 gram is commercial. After 250 gram.
250.
250. Here, 50 times less than the entire quantity. So, my lord, on this ground, my lord, because there is no more witness left to be examined who will come and say that they saw accused person keeping the contraband inside the shop of Noor Jahan. Except Noor Jahan, there was nobody. And nobody can say now that. They may say that, yes, Noor Jahan said to them, police personnel, that she kept, but there is no other witness. So, my lord, so far as they have alleged section 27 also A, my lord, this honorable court was pleased to observe at that point of time, after absorbing the material and all these things, your lordship was pleased to observe that there is no element of section 27A. It is reflected, my lord has already in paragraph, page number 45. My lord has, which has been upheld by the Honorable Supreme Court also, this judgment.
27.
My lord, 45.
Financing.
Yes, my lord. And that is not, even during trial also it has not come. At the beginning only, my lord was pleased to observe. And even during trial, 7 witnesses, there is only official witnesses left. They will not come and say. Only all the vital witnesses, private witnesses, they have been examined. So 45, my lord, page number 45. Paragraph number 15. In this regard, this court has also perused the material on record, including the charge sheet, and has prima facie failed to find any link or even evidence to prove that the petitioner has committed an offence under section 27A of the Act. However, such observation is made only for the purpose of instant application and should not affect the opinion of trial court, which will consider the case of the parties institutionally on the basis of evidence. At the very beginning, my lord was pleased to observe. Now, even I have enclosed the entire evidence of this 1 to 7, my lord. Nothing has come that I have financed or to whom I have financed. But my lord was pleased to observe at the very beginning, without even going through the deposition of witnesses which were supposed to be examined. Now, even after examining all the witnesses, almost all, your lordship, there is no element of section 27 as of now. So on this ground, my lord, that considering that a small quantity of contraband has been recovered, punishment has been already suffered more than the punishment prescribed, and even if, my lord, entire contraband is to be taken into consideration, then also, my lord, applying the principle of proportionality, like contraband and punishment, it is more than enough, my lord, that at this stage I have suffered. So at this stage, my lord, I may be allowed to go on bail.
My lord, at the outset, my lord, normally, my lord, in this kind of cases, my lord, lordship had granted bail in many cases. But why in this particular case it was rejected by my lord? Because this case has got a very checkered history, my lord. Firstly, my lord, she is habitual, she is kingpin, and she is referred as Queen Bee of the drug trafficking world, the racket. She is famous by that name, my lord. Now, my lord, why the case, the bail was refused in this case, my lord? My friend has read what was favorable for him, my lord. What thereafter followed, my lord? Kindly come, my lord, to page. Page 46, paragraph 17 and 18, if I may read, my lord. Again, it may not be out of place to refer to the principles of bail jurisprudence, where more often than not a court, while considering a prayer made for grant of bail, is guided by the age, bail and not jail. However, a court, while considering an application for grant of bail, is guided by certain factors and parameters to be followed before passing any effective order in such regards. Consideration of criminal antecedents of the applicant, that is number one. Likelihood of such applicant repeating commission of a similar offence and the like are also to be considered. Para 18, though as has been submitted and accepted by this court that the provisions of section 37 is not applicable to the case of the petitioner herein, however, it cannot be said the principles or the spirit of the said provision is not applicable. Another aspect of the matter to be considered more particularly in cases of this kind, where consumption, possession and trafficking or peddling of contraband narcotics substances has affected not only a particular individual but has a cascading effect on members of the society, particularly the youth, the ramifications of which has invaded personal and private spaces of the citizens, incidents of looting, burglary and theft being example of the same. Therefore, the court, while considering prayer of kind made in this instant petition, has to balance individual rights as against societal interests. So on this ground, my lord, this particular bail was rejected, my lord. Observing on the foregoing para, my lord, there are a number of other cases in Molai, Lumdingjiri, 3 cases, my lord. She was even detained under the, my lord, prevention of, my lord, illicit trafficking under NDPS Act, my lord. Of course, that period is over. Now, my lord, at that particular point of time, with at the first round of bail application, my lord, the petitioner has cited there were total number of 11 witnesses, and it was moved in the month of August, last month, my lord. And out of the 11, 2 were already, my lord, examined by the court. So, my lord, at the fag end of this first order, my lord, had observed that there is no delay. So, therefore, no interference, my lord. Now, exactly based on that, my lord, this matter was, SLP was filed before the Supreme Court. And Supreme Court has upheld the very observation of my lord, and did not interfere, rather opted for, my lord, a speedy trial, my lord. Now, the first bail application was moved in the month of August, my lord, followed by September, October, November, December, January, February. Out of the 11, my lord, the trial court below has already examined 7. They have done it very rapidly, my lord, taking into consideration of my lord's observation and the apex court, my lord. So, my lord, there is no change of circumstances, my lord. That is my respectful submission, because the apex court has only directed, rather opted for, my lord, a speedy trial. Now, out of the 11, my lord, 7 has already been examined within a span of just 5 months, my lord. So, what remains is, my lord, another 4. So, therefore, my lord, this particular case, my lord, need no interference, and particularly taking into the consideration that, my lord, she is a habitual trafficker, my lord.
Yes, sorry to interrupt. How many cases is he involved in?
It is already here reflected in your order, my lord.
I have mentioned, my
There are
lord,
3, my lord.
2 cases.
Three, my lord.
3, she was acquitted in one case.
Exactly.
She was acquitted only this case and another case. 2 cases
And
are.
what is the stage of the other case?
Other case is 1 witness left, so that I'm not moving on that.
Is she still in custody in that case?
Actually, your lordship, this bail was granted to her in that case.
That case.
My lord,
So
because
it
there
was
a
cancelled
violation
because
the
of
bail
this.
conditions, and
So
it was, my lord,
because of
cancelled.
this new case, this case, it was cancelled.
Oh, but
So thereafter, again, if
My
this
lord,
one,
Now, my lord, in the first case, what had happened, my lord? She was granted bail. And one of the bail condition was that not to repeat the similar offence. So subsequently, she committed this offence, my lord. That bail was being cancelled, my lord. So therefore, my lord, there is every likelihood she will
now,
commit.
So now, see, I mean, factually,
yes,
she's still in custody
yes, yes,
in another case.
yes, yes,
Even if bail is granted here,
Yes.
she'll still be in custody.
Exactly.
that is different thing, my lord, because
No,
the one
different thing,
witness
no,
left.
no,
Yes,
different
yes,
thing, but that aspect has to be considered.
yes, yes.
Considering the fact that see now what the court at this point of time will, will try to pursue it.
Yes.
The trial court is for the expedite the trial,
Exactly.
which, as Mr. Guru has said, has been done so. Out of 11 witnesses, 7 have been examined.
13 witnesses are there.
Whatever. So maybe 5, 6 are left. So perhaps in a matter of 1-2 months.
There is no possibility, my lord, that it will be. If your lordship
My
will
lord, in
direct
5
that.
months we have
That
completed
because
7.
If
see at this point of time, if you
yes,
if you agree, what the court can do is will impress upon the trial court to expedite the hearing.
Well,
that
As has
direction.
been, as has been, it's a reiteration of the apex court order,
Yes,
Exactly.
my lord. Yes, my lord.
so that this matter, this particular case will be concluded, because you still have another case to fight.
That is one witness left. It will be, and I will be out only, my lord, because I am confident that no, that means I am doing the
See,
trial.
because
So, my lord, one of the
like
My
I
lord,
said,
if that possible,
practically speaking, even let's put it this way, I'm not saying that this court will grant you bail. Even if bail is granted today, you'll still be in custody.
exactly.
So we don't know what will be the fate of the other case.
Exactly.
my lord, I am just, my lord, granting of bail and refusing of bail. It casts serious mental trauma to the accused. If this bail will be considered, my lord, because I cannot be punished for more than what the punishment prescribed.
That is because
So
the
only
trial is
because-
see, the trial is not concluded. At the conclusion of the trial, when the trial court pass its verdict, it may come to a finding that yes, we are liable only for possession of small quantity, for which sentence has already been undergone. That's a
Exactly,
different thing. But this court cannot
exactly,
take
my
that
lord.
place.
As of now, the trial is going on intermediate quantity, my lord.
Intermediate quantity also, my lord, I have the ruling that punishment for 9 gram, your lordship, it cannot be more than 2 years also. So no, my lord, my only submission is that, my lord, I am pressing for the bail at this stage in this case, and their purpose will also be served, my lord. If in that case their purpose, because I will be again inside the court, inside the this one custody.
Whatever the case may be, you have to understand, Mr. Pandit, you are very sure. I mean, it's apparent. Bail jurisprudence and principle of bail jurisprudence says that there are parameters for consideration of bail. Number one is if there's likelihood for the accused to flee or to abscond, which may not be in this case since you are in custody. Number two is to see your criminal antecedent.
Exactly.
It's a very strong
Yes,
factor.
yes.
You are involved in 2-3 cases.
Yes.
That by itself, constitute criminal antecedent, which you have to, to clear yourself in due course. But as of now, that factor will weigh heavily.
My lord,
So at the most, I will dispose of this petition only on that observation.
then, my lord, direction will be given that within 2 months it will be trial will conclude.
Again, time frame cannot be given. You see.
Time
Because
frame
that another
Law.
it will
No,
take your lordship 6 months,
No,
another 6
we
months.
will say 6 months, but
law is settled on that. Expedious,
maybe,
My lord,
but time frame
maybe
cannot
you see,
be given.
on the basis of this court's order, you can approach the trial court and say that this is the observation, and
My
this is
lord, the Honorable Supreme
apex
Court has-
Apex Code observation is there.
Exactly, my lord. We cannot
My
bypass
lord,
that.
the Honorable Supreme Court has already given direction, and in various cases
No
also
time
direction
frame.
has been given the day-to-day trial. But in this case, my lord, 15 days and production is there, and after 1 month the evidence used to be taken up.
Maybe day-to-day trial.
So, my lord, I'm just saying that, my lord, submission is that, my lord, when a person has already been suffered, the period for which the punishment is
That is, you see, that has not been, not been settled. That is your submission.
Yes.
Perhaps evidence would say so, but yet again, the trial court has not passed the final order. So how can you say that? It may change. It may alter. It may alter the the charges also. We don't know.
But, my lord, I have placed all the evidence.
You have placed
And
but this is not. This is not. It is not for this court. In bail, in a bail application, it's not for this court.
No,
to
I am
appreciate this evidence.
yes, my lord. Just to bring the change of circumstances, I have enclosed all those evidences, and the most vital witness
If
that
that kind of
which-
observation is made, my lord, it will have a, my lord, that rippling effect on the trial, my lord. Influencing part, my lord. So therefore, my lord,
that can
cannot
be taken
entered.
care of by this honorable court also, that this observation cannot be taken.
No,
that can be done.
The court will give that observation.
Fine.
I will reiterate whatever the Supreme Court has directed.
Exactly.
So, my lord, then again it will be another 6 months. It will take, by the time I will be suffered more than the punishment prescribed in this case. Only because my criminal antecedent is there, my lord, then I cannot be detained. Otherwise, why they can invoke the preventive detention?
Actually, my lord, that,
preventive,
that will
if
be
that
the
fear is there,
most important ground, my
if
lord.
that fear is there,
What is the order of the? What is the date of the order of the
5/8.
Supreme Court?
This is your lordship. 17/9. 5 months over. It's page number 48, my lord.
48.
48.
17.
5 months has gone, my lord. 5 witnesses has been examined after that. So 1 witness, 1 month. And, my lord, the thing is that when evidence has already come, my lord, that and the punishment I have already suffered, then antecedent cannot override the.
We are parroting the same line again and again.
Only thing is this. Yes, I do agree. Trial court will take each case in its own facts and circumstances. It will not be influenced by the accused being involved in some other case, which.
That is the thing.
But nevertheless, we cannot lose sight of the. Again, I'm reiterating. We cannot lose sight of the fact that she is already in custody in another case, which practically will not help you.
My lord, only I respectfully submission. I'll just one more submission that, my lord, if this bail will be considered, my lord, I can file another bail application in that case also. So only because one case is pending, other case, then where I will get
bail was being cancelled, my lord. Guaranteed bail cancelled, my lord, because of the criminal antecedents.
And, my lord, the thing is that if the fear is that I will commit any offence, then why there is no again preventive detention? By rejecting the bail, my lord, again it amounts to preventive detention only for me. The government is, if so much worried, then
She
they
is
should.
the first lady to go under preventive detention
First
in
lady,
Meghalaya.
second lady, then if that fear is there, then they can invoke again that preventive detention against me. This honorable court, my lord, if rejecting the bail, then it amounts to preventive detention only, my lord.
How is that? That is a very.
Again, although I am entitled, and only because one case is pending and then I have criminal
No, that is
antecedent.
not the only observation.
I'm not saying that. It is not the order of this court will not be on that basis. Not on that basis. It's only, again, I'm saying, it will be only on the basis of your criminal antecedent. That's all. But Mr. Pandit, under counsel of the petitioner, who has submitted that the petitioner hearing has once again approached this court, will pray for grant of bail. And earlier prayer being made was rejected by this court by order dated 5/8/2025 in DA number 37 of 2025. in due course. You have applied for grant of bail before the trial court again.
Yes, I have applied for
Where is that
bail.
order? I just now I saw the order. Where is that order?
Already,
It was rejected on 9/2/2026.
In due course, in due course, the petitioner has again prayed for grant of bail on the ground of changed circumstances, the said prayer was made before the learned trial court in bail application number 16 H of 2026, but the same was rejected by the learned trial court by order dated 9/2/2026. At this point of time, now, the petitioner has approached this court with this instant bail application with a prayer for enlargement on bail. On the ground that in course of proceedings before the trial court and from the evidence of the witnesses who have since deposed, evidence of the prosecution witnesses who have since deposed before the trial court, it transpired that the petitioner accused has not committed any offence or any offence of possession of contraband substance of a quantity more than the prescribed small quantity, and even if the petitioner accused is to be punished for such an offence, the having undergone custody, having been in custody for more than the prescribed period of punishment for possession of contraband of small quantity, therefore the petitioner accused is entitled to be released from custody. Next, in this regard, the Learned Counsel has led this court to the evidence of one of the prosecution witnesses, namely Noor Jahan, who is said to be the person who has informed the police at the initial stage of the case that the petitioner accused had kept or hidden certain amount of contraband substance in her shop. However, in course of her evidence before the court, the said witness has made a U-turn and has deposed that she had never made any such allegation or statement against the petitioner accused. This piece of evidence has justified the case of the petitioner accused as far as the allegation of her being in possession of the alleged contraband substance of about 6.6 grams something.
Yes, my lord. 6.5 gram.
6.5 grams concerned. On the basis of such changed circumstances, the learned counsel has prayed that the petitioner may be allowed to go on, may be released on bail with any condition fit to be imposed by this court. Next, per contra, Mr. Argo, learned counsel, has submitted that this court, in the first instance, when the first bail application was preferred, that is BA number 37 of 2025, comma, right order dated 5/8/2025, the prayer of the petitioner herein was rejected. Not necessarily on the consideration of the alleged possession, the alleged quantity said to be possessed by the quantity of contraband said to be possessed by the petitioner accused, but that the bail was rejected on the ground of her involvement in similar offence involving contraband substance, for which 2 other criminal case was instituted against her. Therefore, on consideration of her criminal antecedent, this court has rejected the prayer made then. Next, it is also the further submission of the learned GA that the petitioner may aggrieved by the said order dated 5/8/2025 has approached the Honorable Supreme Court, and the Honorable Supreme Court by order dated 17/9/2025 has rejected the appeal, thereby upholding the order of this court. The Supreme Court has however directed the trial court to expedite the trial. Under such circumstances, since there is no delay in the trial, therefore the prayer for grant of bail may not be allowed at this point of time. Further submits the submits the letter G. Next, this court has considered this submission of the party and is also made aware that the petitioner herein is also in custody in connection with another similar case involving offences under the NDPS Act, and for which trial is also proceeding in that case. Next, as to the contention of the learned counsel for the petitioner that in view of the evidence tendered by the relevant witnesses, the petitioner is deemed to have been, the petitioner at most is deemed to have been in possession of a small quantity of contraband substance, for which, being in custody for the relevant period of time, he ought to have been discharged from the case. Now, to paragraph. This court is of the considered view that the matter is sub judice, since the final order of the trial court has not been passed. As such, it could not be said that the petitioner accused would be found guilty or innocent at the end of the trial. Therefore, this would not be a point of consideration as far as prayer for bail is concerned. Next, be that as it may, on an appreciation of the facts and circumstances involving the case of the petitioner, at this point of time, there is no ground for grant of bail. There is no ground for grant of bail has been made out. This petition is accordingly dismissed. Before parting, this court would impress upon the trial court to expedite the case of the petitioner accused in view of the direction made by the Honorable Supreme Court Supra. Now, I need to get it. You have to order Supreme Court. Perhaps, if possible, a day-to-day trial will be conducted in this regard.
Okay. Deputy.
Petition disposed of.
From daily list, item number 12.
Yes. You are in this case?
My lord, this matter, my lord, is listed under for the special mediation drive. Lordship may kindly recall, this is that Waqf board matter.
Oh, that election thing?
Yes, ma'am. Yes. Waqf board matter where government, my lord, state had issued a notification appointing me and other people as members of the board. Petitioner is alleging through the petition that the notification is bad in law. It's against the provisions of the act. So I'm not sure what the stand of the petitioner is as far as the mediation is concerned. But if Lordship allows me to humbly point out that the chances of any sort of success may be next to none, for the reason that state has issued a notification. They are alleging that notification is illegal. Any mediation would involve state agreeing that yes, it was illegal and withdrawing it. State, I'm certain, will not agree to that. We will never agree to the withdrawal of that notification. They will not accept anything less than the withdrawal of the notification. So, I mean, on a general matter of principle, one should always go for mediation, but certain matters,
Yes,
my lord,
of course.
may require a judicial adjudication, my lord.
I'm appearing for the state. On the parties not agreeing to mediation at this point of time, matter is accordingly referred to. Matter is accordingly to be taken up in due course.
Item number 13.
That compensation matter.
Yes, madam. Yes.
This involves MECL.
Lordship,
MECL, my lord.
am I praying for the cooperation, my lord?
Yeah, for compensation. Why?
You can give a try, my lord.
Give.
So,
This court has given. No, I'm not saying the final verdict, but
hints have been given.
Inclination. Because question of, you see, when it comes to issues of tortious liability. Anyway, you try.
My lord. The only thing is that the petitioner is incapacitated. He may be allowed to appear online if required, my lord.
Yeah, that is for you and the mediator to decide.
We'll work it out.
On parties agreeing for mediation, that is referred to mediation committee for appointment of a mediator.
Understood.
Item number 14.
Who's there?
For the state, not sure.
Mr. Sincon is not here. None appears for the petitioner. Matter to be taken up at some other point of time.
Hello.
Item number 15.
Lordship, let this matter go for mediation.
It may be referred.
Because there are not only one petitioner here, 2 or 3 or how many? 2.
So that 2, I believe. Lordship.
2 petitioners.
Try and see. On parties agreeing the matter to be referred for mediation, accordingly, that is placed before the mediation committee for appointment of a mediator.
Hello,
Item number 16.
Yes, Mr. Dev.
Lordship, this can go for mediation.
Actually, Lordship, all the respondents are yet to enter appearance, and the respondent who has issued the impugned order has not yet entered appearance.
Oh, this is 2025.
Yes, Lordship. So there's no point.
What is the case about?
Lordship, here what happened, Lordship, I passed from CMG University, and during verification it was found that my degrees are not matching. So that's why that certificate or the letter was issued by the respondent number 4. So the respondent number 4 are yet to enter appearance, though the service of notice is complete. So there's no point, Lordship.
This submission is made by the parties that this matter is too premature for reference for mediation, on the ground that all the parties involved are not in attendance for a court, not yet in attendance for a court. Accordingly, matter to be taken up in due course.
Much obliged.
Item number 1.
May it please your lordship, I'm appearing for respondent number 4 to 12. So, as per the last order, your lordship, you have passed the order to file for the affidavit for opposition, so we will file positively on Monday, your lordship. As the affidavit has already been done, it's except for the parties that haven't come to the chamber, your lordship, for the signature.
Well, let it be reflected that they filed positively because they've been asking time and again, Your Lordship.
Yes, positively, your lordship. We'll do it on Monday.
Mr. Counsel for the respondent. Respondent 4 to 12
Yes, your lordship.
has once again has submitted that the affidavit in opposition by such respondent is ready. However, the deponent could not be. However, the deponents are yet to swear the said affidavit, for which some time is prayed for. Accordingly, as prayed for, this is matter to 1 week.
Oblige, Your Lordship.
Good day, your lordship.
Item number 3.
Please, Lordship. In this matter, we are required to file paper book.
Item number 4.
Well, here the appellant has concluded the argument, my lord.